Welcome to the deep dive. Today, we're doing something a little different, almost like a piece of legal archaeology.
That's a good way to put it.
We're tracing the DNA of probably the single most important principle in family law anywhere in the world, the welfare of the child.
Right.
And when you think about modern custody law, the standard of the child's best interest, you probably assume it's a modern invention.
Of course. Maybe something out of 20th century psychology, codified after World War II, that kind of thing.
Exactly. But that assumption is precisely what our sources today just completely blow apart.
They really do. We've got a remarkable stack of material here that shows this core idea, the principle that a child's welfare comes before the competing claims of the parents.
Yeah.
Didn't just pop up in the modern era.
Not even close.
It actually stretches back almost 14 centuries. It originates in a judicial ruling that was, for its time, just revolutionary.
So we're synthesizing sources that bridge these huge gaps, both in time and culture. On one end, we have 7th century Islamic law.
Specifically, the rulings of Caliph Ali ibn Abi Talib.
And on the other end, we're jumping to modern statutory law in the UK. We're looking at the Children Act of 1989.
And then we're looking at how those two streams, the ancient and the modern, were harmonized in Pakistan through their Guardian and Wards Act of 1890.
So our mission today isn't just to list what these laws say, it's to synthesize them. We want to show how this profound idea, this shift from parental rights to child welfare, how that became a universal standard.
It's a story about the endurance of a just idea.
So the big question we're unpacking is this. How did the idea that the child's welfare takes precedence over the claims of the parents become the gold standard across such different legal systems spanning more than 1,000 years?
A great question. And to answer it, we have to start at the very beginning.
Let's do it. Section 1, the birth of child-centered justice.
Okay, so we have to transport ourselves back to the Arabian Peninsula, 7th century. We're looking at the foundational judicial work of the 4th Caliph, Ali ibn Abi Talib.
And to really get how big a deal his ruling was, we need to understand the context. What was the norm back then?
The norm, not just there, but pretty much globally at that time, was to see childhood through the lens of patrimony, of property.
So a child was basically an extension of the father, the head of the household.
Absolutely. Custody, care, those things were tied to lineage, control, and who could provide materially. The default was almost always the father or the father's family.
The legal system, then, was set up to protect the household, the family name, the assets.
Not the emotional world of the kid.
Yeah.
Exactly. Children were essentially objects of rights.
Not subjects with rights.
That's the perfect way to put it. Legal fights were about wilaya.
Which is guardianship.
Yes, guardianship. Authority over property, legal decisions. And they were about hizana.
And that's the physical custody part, the day-to-day care.
Right. And the assumption was that the person with the most power, socially and financially, which was usually the father, had the stronger claim to both.
But Caliph Ali, he comes along and just moves the whole conversation away from that. The sources are clear. He established a principle that, for the 7th century, was just incredibly progressive.
The welfare of the child takes precedence over the claims of the parents.
That one sentence changes everything.
It's revolutionary because it's not just a nice saying. It's a legal tool. It forces a judge to put the dependent's well-being first, above the claimant's power or their wealth or their social standing.
It shifts the entire judicial question. It's no longer who owns this child.
It's who can best nurture this child.
I think we need to just sit with that for a second. If you look at other legal systems from that time, or even centuries later, like Roman law.
The paterfamilias.
Right. The father had absolute control. So for a judge in the 7th century to just declare that the child's well-being is the #1 legal factor, not tradition, not wealth, that is a massive leap.
A huge moral and legal leap.
So how did this play out in a real case?
It was applied in this landmark case that our sources detail, and it really captures the whole doctrine perfectly. A dispute comes before him between a mother and a father recently divorced.
And they're both claiming custody of their young son.
Right. The father steps up, and he basically makes the traditional argument, the argument from power.
The one based on all the established norms.
His arguments, as they're recorded, were very direct. I am stronger. I can provide more.
And the child will learn from me, which basically means he can give the boy the training he needs to be a man in that society.
He's representing that traditional power-based claim.
And the mother's response is just, it feels so timeless. It's the counter-argument that's rooted entirely in care.
Her whole point appealed directly to that physical and emotional reality of a child's early life. She says, I carried him, I fed him, I nurtured him.
It's not a claim about money or power.
No, it's a testament to Hosanna, that daily, sustained acts of nurturing and bonding. She was basically arguing that this biological and emotional truth should be more important than formal legal authority.
And the decision Ali makes right then is maybe the most incredible part of this whole 1400-year story. He doesn't just issue a ruling from on high.
No, he engages the child. He effectively gives the child a voice in court for what might be the first time in legal history.
What did he do?
He asked the young boy to choose.
Wow.
And the sources say the child just walked over to his mother. That simple action, soliciting the child's own preference, it was a seismic shift. It's an acknowledgement that even a young child has a valid preference, one that's rooted in comfort and attachment.
And the ruling that came from that action, the legal reasoning, it becomes the foundation for centuries of custody law.
The final ruling was this. The mother is more entitled to young children unless she remarries or fails in care.
So it's clear it's prioritized, but it's also conditional.
Entirely conditional. And it's based completely on the child's need for stability and nurture.
Okay, let's break down the legal pillars that this one ruling established because they are still so relevant today. First, you have maternal priority in early childhood.
Which is basically the law recognizing that unique bond and physical dependency of the early years. It says that yanking a child away from their primary caregiver is, by definition, bad for their welfare.
Second, the child's preference. It's now a factor if the child is old enough to have a real choice. It gives the child's own emotional reality a place in the legal system.
Third, and this is the big one, the best interest of the child becomes the paramount, the most important consideration. This is the legal switch that subordinates parental rights.
So if a parent's claim, even if it's technically valid, conflicts with the child's best interest.
The child's interest wins. Every time.
And fourth, and this is so critical, custody is decided by care capacity, not just by gender.
Right. The ruling was conditional. The mother gets custody unless she fails in her care or if her remarriage is bad for the child.
So it's not an absolute right for her either?
No, she holds custody because she's the best caregiver, not just because she's the mother. And this ruling also powerfully stated that financial strength does not trump emotional well-being. The father's claim of being able to provide more was legally defeated by the child's emotional need for his mother.
That single ruling really created a template. So how did later Islamic scholars and jurists build on this?
That's where it becomes embedded in the legal system. Over the next few centuries, these principles were formalized by jurists across all the major schools, Hanafi, Maliki, Shafi, Hanbali, and in Shia jurisprudence as well.
And what did that look like in practice? The Hanafi school, for instance.
The Hanafi school, which is very influential, really doubled down on the idea that Hosanna is a right of the child, not the mother.
Oh, that's a key distinction.
It is. They set out specific age limits for maternal custody, like for boys until they're about 7, for girls until puberty, but these were all based on the developmental needs of the child. The stability of the child's life was sacred to them.
So even if the exact ages differed between the schools, the core principle was the same.
Absolutely. The universal mantra that emerged was welfare over ownership, care over power, stability over technical rights. They even built in rules to ensure the father still had to pay for financial maintenance, the nafaka.
Ah, so he couldn't use money as a weapon to get custody back.
Exactly. It was a sophisticated system of child protection that really set the standard for over 1,000 years.
Okay, so now we're going to take this huge leap forward in time. We're leaving the 7th century and landing in late 20th century Britain.
It's a massive jump, different continent, different legal tradition.
Yeah.
But we arrive at the exact same ethical conclusion.
We're turning to the UK's Children Act of 1989.
And what's so interesting here is that this principle didn't come about in the UK just from, abstract legal philosophy. It came from a reaction to failure, to crisis.
What do you mean?
For centuries, English common law had the standard paternalistic model. The father was the natural guardian. That was the default.
So even if judges tried to consider the child's welfare, the law itself was still tilted towards the father's rights.
Heavily tilted. The old legal framework treated parental rights almost like property rights. Welfare was a factor, sure, but it was just one factor among many.
But then something changed in the UK.
The 1970s and 80s were rocked by these huge, high-profile scandals involving child abuse and neglect. The Cleveland child abuse scandal was a major one.
Right, I remember that.
And these events put enormous pressure on Parliament to completely overhaul how the courts and the state dealt with children.
So the 1989 Act was a direct answer to the old law's failure to protect kids.
It was a direct response. The sources show the 1989 Act was designed specifically to get rid of that old idea of superior parental rights. It took the principle we've been tracking and formally wrote it into law. The child's welfare shall be the court's paramount consideration.
Paramount. That's the key word, isn't it? It means it's not just a consideration, it's the consideration. It trumps everything else.
It is the legal hammer.
Yeah.
And what it meant in practice was a total shift. The very concept of parental rights was legally abolished.
Abolished. What was it replaced with?
Parental responsibility.
Hmm.
And that change is so important. A right is absolute. A responsibility is conditional. It's conditional on you actually meeting the child's needs.
So if you fail in that responsibility,
Your technical claims as a parent become secondary, the state can step in.
and the court's focus shifted to what's known as the welfare checklist.
Yes, the act wasn't just a philosophical statement. It created this very detailed mandatory checklist in Section 1.3 that judges have to go through in every single case.
It makes it objective. It's not just up to one judge's gut feeling.
Exactly. It provides a framework.
So what's on this checklist? What does a UK court have to look at?
There are 7 key areas. First, the child's own wishes and feelings, taking their age and understanding into account.
Which is the modern version of Ali asking the child to choose.
It is. Then, the child's physical, emotional, and educational needs. And a
Yeah.
really critical one, the likely effect on the child of any change in their circumstances.
So stability is baked right into the law.
Explicitly. The court also has to look at the child's age, sex, background, and then the actual capability of each parent to meet the child's needs.
So it's not about who has a bigger house. It's about who is the better parent in practice.
It's entirely about demonstrated parenting ability. And finally, the court has to consider any harm the child has suffered or is at risk of suffering. It's an incredibly thorough list.
And this whole framework allowed the UK to bring in totally new systems to enforce this principle. It went beyond just custody fights.
Oh, absolutely. The state's power to intervene grew a lot. The act set up formal guardianship safeguards, so people who aren't the parents, like a court-appointed guardian, could step in.
And social workers' assessments became much more important.
They became central. Mandatory social work reports, these objective investigations into the home life, the school, the child's attachments, they replaced the court just having to rely on 2 parents arguing. It grounds the decision in the child's actual reality.
And we also saw the creation of roles like the court-appointed independent children's guardians.
This is maybe the clearest sign of how serious they were. An organization like CAFCAS provides an officer whose only job is to represent the child's interests.
So they're the child's lawyer, in a way.
They're the child's independent voice in the legal process, separate from the parents, separate from everyone. It ensures the child isn't just a passive object in the fight.
So if you pull it all together, the UK, 1400 years later, ends up at the same ethical place that Ali did.
The primacy of the vulnerable. It just took a massive, modern, bureaucratic, and legal machine to get there. It shows the principle isn't tied to one culture or one time. It's tied to the definition of justice.
Okay, let's move to our third section. Here we're looking at a different kind of legal story. Not creation, not codification, but harmonization.
That's right. We're looking at Pakistan, where the courts had to do something really complex. They had to fuse that ancient Islamic jurisprudence we've been talking about with a very different legal foundation.
A colonial one.
A colonial one, specifically the Guardian and Wards Act of 1890.
So this is a law from the British Raj. It's the main statute in Pakistan for anything involving minors' guardianship, custody, visitation.
And because it's a colonial law, it was written with the language and norms of 19th century British India.
So the courts in Pakistan are faced with this challenge. They have to apply a common law statute in a country where family law also has to follow Islamic principles. That must require some really sophisticated thinking.
It does. The courts basically engaged in what you could call a fusion process. They didn't just throw out the 1890 Act. Instead, they took its broad clauses, like the part that says you have to consider the welfare of the minor.
And they interpreted that phrase through the lens of Islamic law.
Precisely. They reread the statute, transforming this colonial inheritance into something. So, Maqasid al-Sharia means the higher objectives or the ultimate goals of Islamic law. It's a way of looking past the literal text to understand its core purpose.
Okay.
In family law, the key objectives are the preservation of life, intellect, property, and, crucially for our topic, nasl, which means lineage, family, and dignity.
So how does a higher objective like preserving lineage and life help you interpret a 19th century British law. That's the really interesting connection here.
It gives you the ethical why. If the ultimate goal is to preserve the child's life, their intellect, their family ties, then the court must interpret the 1890 Act in a way that gives the child maximum protection and stability.
So, for example, preserving lineage means the court has to protect the child's relationship with both parents.
Right, which is why they started treating visitation as the child's right. And preserving intellect and life means prioritizing emotional stability and education over, say, moving for a higher paying job.
So the Pakistani courts used the Maqasid to basically infuse the spirit of that 7th century ruling into the body of the 19th century law.
That's a perfect summary. And this fusion process led to 7 specific judicial principles that have become landmarks in Pakistani law.
Okay, let's run through them. Principle 1 is the cornerstone. Child's welfare is paramount.
That's the universal starting point. The courts in Pakistan are crystal clear. Welfare is the yardstick. It's identical to the UK's paramount consideration.
Principle 2. Mother has preferential custody for young children, sons under 7, daughters until puberty.
A direct import of the traditional Hizana rules. It recognizes the mother's role in the early years. But, and this is key, it's always subject to that paramount principle of welfare. It's a preference, not a blind rule.
Which brings us to Principle 3, which is a really clever distinction. Father remains the natural guardian, but custody is based on care capacity.
This is maybe the most sophisticated part of the framework. Wilaya, legal guardianship, that often stays with the father. That's for things like property, major legal decisions. But Hizana, the actual physical custody, that goes to whoever is the best caregiver.
So the father stays legally and financially responsible, but the child stays with the parent who provides the best care.
Exactly. It separates legal authority from the reality of caregiving.
Principle 4. Child's preference is considered if they're mature enough to have a reasoned choice.
And the courts really look at the reasoning. Is the child saying this because they feel safe and stable, or because one parent promised them a new video game? If the choice is mature, it carries a lot of weight.
Okay, Principle 5 is a big one. It deals with the mother remarrying. Remarriage is not an automatic loss of custody unless it's proven to be bad for the child.
This is a really important modern refinement. Historically, if a mother remarried, she often lost custody automatically.
Why?
Because the new husband was a non-relative, a stranger to the child. But the courts realized this was often just punishing the mother and disrupting the child's life for no good reason. The modern rule is you have to show actual proof that the new home environment is harmful.
It puts the focus back on the child's actual experience. Principle 6 goes right back to that 7th century case. The father's financial superiority does not win him custody.
This is a powerful and consistent rule from the courts. You cannot buy custody. If the mother provides a loving, stable, adequate home, the father can't win just by showing he has more money. The Supreme Court has said time and again that emotional security is worth more than material advantage.
And finally, Principle 7. Visitation rights are a child's right, not a parental favor.
A critical reframing. The court orders contact because the child has a right to know both parents, to know their family. It stops the custodial parent from using access to the child as a weapon.
These principles are really robust. Let's look at a couple of the specific cases the sources mention. The PLD Lahore ruling.
That ruling is so important because it dealt with this conflict head-on. The father's technical right as guardian versus the child's welfare. The father claimed his inherent right
As the legal guardian.
Yes. And the court said, essentially, that the 1890 Act, when read through the lens of welfare, makes your technical title irrelevant if you can't prove you're the better caregiver. The ruling explicitly states welfare overrides all technical rights.
Then there's the KLR 2000 Karachi case about educational stability.
The great practical example. The court was asked to move a child from the mother to a father who lived far away but offered a richer life. The court said no.
Why?
Because it would disrupt the child's schooling, their friendships, their entire routine. The judges basically said that uprooting a child's established life is, by itself, harmful to their welfare unless the current situation is actually bad for them.
And finally, the SCMR 2013 Islamabad ruling, which made emotional bonding a legal factor.
This is where you see the law really integrating modern child psychology. The court legally recognized the quality of the emotional bond between the child and the parent. It's not just about food and shelter anymore. It's about psychological safety and attachment.
So the common thread, the judicial mantra that comes out of all these cases is very clear.
The child's life must not be disrupted without compelling reasons.
And that phrase acts like a shield for the child.
It does. It puts the burden of proof squarely on any adult who wants to change the child's life. It makes stability the default. It's the ultimate defense mechanism for a vulnerable child.
So this has been an incredible journey. We've seen a principle born in the 7th century, formalized in the 20th, and then harmonized in a modern state. Now, in this final section, let's pull it all together and look at the universal ethic that emerges.
The comparative table in our sources makes it undeniable. You have these vastly different systems separated by centuries and continents, and yet they land in the exact same spot.
Let's look at the language they use. Islamic law calls the child's welfare supreme,
The UK statute calls it the paramount consideration.
and Pakistan's courts call it the overriding principle.
Supreme, paramount, overriding. These aren't just words. They are legal terms of art. They all mean the same thing. The child's interest functions like a supremacy clause. It beats every other claim.
And what about early custody? The 7th century rule and Pakistan both explicitly prioritize the mother. The UK law is more neutral, it's just welfare-based.
But in practice, the UK's welfare checklist often gets to the same place. By prioritizing the primary attachment figure, the main caregiver, which in the early years is very often the mother.
So it achieves the same outcome without using the same gendered language.
Exactly. The result validates the original insight.
And the child's voice, that moment when Ali asked the boy to choose, that's now a feature everywhere. All three systems consider a mature child's preference.
This is maybe the clearest link across all 1,400 years. It confirms that children are seen as developing human beings whose own experience of the fight matters.
And most fundamentally, the basis for custody is the same everywhere: care, parenting ability, emotional stability.
All of those trump a simple legal claim or having more money.
That original argument from the 7th century father, I am stronger, I can provide more, is legally dead on arrival today in London, in Lahore, and in Sharia courts.
It is a total victory of nurture over power.
So this all leads us to one single, universal legal conclusion. The ratio decidendi, the reason for the decision, across all these systems. What is it?
It's a complete reframing of what custody is. It's this. Custody is not a parental right. It is a child's right.
Wow.
Once a legal system accepts that single premise, everything else falls into place. The child's welfare has to be paramount. Custody stops being a prize you win.
It becomes a duty that's assigned to the person best suited to perform it.
Exactly. The court's job changes from being a referee between two adults to being the protector of the child's future.
So if we sum up the roles of each system in building this ethic,
Caliph Ali ibn Abi Talib created the doctrine. He laid down the blueprint. The care capacity is what matters.
the UK modernized it. They built the detailed statutory machinery, the checklists, the independent guardians, to enforce it in a modern state.
And Pakistan did the essential, complex work of harmonization. They wove together the ancient religious principles and the inherited colonial law into this cohesive, dynamic legal system that protects children.
The moral of the story, then, the lesson from all this law, seems profound and simple.
Children are not trophies. They are lives to be nurtured, protected, and prioritized.
As society's justice is really measured by how it protects its most vulnerable.
You know, the most incredible part of this whole deep dive, for me, is realizing that this sophisticated legal consensus we have today, this focus on attachment and stability and emotional needs, it's not new.
It's not a modern invention.
No. It is the formal, legal recognition of an ethical truth that was first spoken in a courtroom 1,400 years ago. The principle survived because it was right.
It really flips our idea of progress. It suggests that legal thinking isn't always a straight line from, primitive to modern.
Not at all. Sometimes the most advanced idea shows up early, like a flash of insight, and then legal systems spend the next 1,000 years trying to build the plumbing to catch up to it.
So the UK Parliament's work in 1989 was essentially them building the modern bureaucracy to enforce the ethical judgment Ali made in the 7th century.
In a way, yes. It just took a global human rights movement and the clear failure of the old laws to force their hand.
Okay, so we've established it. The core principle of custody law is that it's a child's right to welfare, and that right is paramount. So let's end with a final thought. What happens if we take that principle and apply it outside of a family court custody battle? What could it mean for broader social policy?
That is the big question to take away from this. If a child's welfare truly overrides adult claims, it has to have an impact way beyond custody. Think about mandatory education.
Okay.
You have a parent's right to choose how to educate their child. But does that right override the child's right to the best possible education for their own future welfare, for the preservation of their intellect?
Or what about the digital world?
The digital world is the perfect modern example.
Digital privacy for kids, it's a huge issue.
Exactly. You have corporations' right to make money from data, your parents' right to monitor their kids. But what about the child's independent welfare claim? Their right to psychological safety, to privacy, to protection from digital exploitation.
Things that are vital for their developing identity.
Do those rights override the parent's convenience or the company's profit model? If the child's welfare is truly the supreme consideration, then our laws on data collection on social media, they have to be designed to protect the child first.
Even if it's inconvenient for the adults.
Even if it costs companies money. It turns this 14th-century-old idea of protection into a regulatory tool for 21st century technology.
That is definitely food for thought. Thank you for walking us through this. This has been an incredible deep dive into the long arc of justice.
My pleasure. We'll see you next time on The Deep Dive.